only at the time of trial that then it also became a perm total. So we went to trial on both issues, unbeknownst to me until the day before. We were also going on permanent total. So those were the benefits I didn't pay because we were disputing that he was permanently total labeled. Right. We were disputing that he was actually at maximum medical improvement. Therefore, the basis of it was not that he's ready and he's a perm total. It was you haven't cooperated with medical care. You're not at maximum medical improvement. Therefore, we can't get to perm total disability.
What's the when the doctor walked out of that position, did you make any effort to compel her to appear to finish the job?
No, I did maybe 4 or 5 pages of an offer of proof as to what I was going to ask. At the time of trial, the arbitrator let the deposition go into evidence without the completion of the cross-examination. I think he felt that he had enough there to make a decision, and the decision worked out. So. Yeah, but at the commission level, it was denied at the commission level and by the arbitrator.
What did you really want the guy to do to cooperate with medically? I didn't think that's,
So the question is, what did the respondent really want this position
So yeah,
to
so
do?
Dr. Zollman had a very long. Oh, sorry.
Okay, can you hear me? Dr. Zollman was very specific about what he needed to have done. There were very specific speech therapy, going to a psychologist, going to, I think, cognitive behavior therapy. There was a whole list of recommended treatment, all of which the respondent authorized and said that they would, provide to the petitioner to undertake. And he chose not to undertake the treatment because he relied on his own doctor. And that's really what the appellate court said. It said it wasn't unreasonable for him to rely on another doctor who was giving another course of treatment. But that was the course of treatment we were asking.
in your review, why did the RIC director implode and cease being involved in the deposition?
I wasn't there, so I can tell you from reading the record, but I wasn't at that deposition. I believe she felt that the questions was too harassing.
You earned her $10,000.
So I'm sure the speakers will be around after if you have any other questions. I want to just finish this last case. So this case we talked about last time, remember, it was an unpublished decision. This is RG Construction, which has to do with an interpretation of Section 16 of the Act. What comes in is treating records and that automatic admissibility part. So the case is published now, okay? So I can actually now tell you what this case stands for, even though I told it to you 30 days ago or 45 days ago what the case stood for. So the really important sentence in this case, to me, is this last sentence, which I highlighted in red, and that's why I did that. After reviewing the statutory language, we find no indications the legislation intended to exclude a treating doctor's opinion, which was offered during the course of the treating doctor's treatment of the employee and memorializing the doctor's treating record from the phrase medical and surgical matters. So what this case says is that if opinions are expressed in the treating record, and those opinions were not expressed strictly for the purposes of litigation, then those opinions go in just like any other part of the doctor's treating records under that automatic admissibility section of Section 16. Okay? All right, thanks for hanging in there. Hold on. Please.
From my perspective, I don't think that case says it automatically. That case says there are times in which they can come in. There are different, as we all know, the fact that someone's diagnosed with a rotator tear, that's opinion. This doesn't necessarily say that there's not still.